Hi, everyone. Welcome. Let's get started. My name's Jason Q. I'm the managing attorney in our nonprofit and small business legal assistance programs here at the DC Bar Pro Bono Center. Welcome to today's webinar, part of our Board Basics series. The topic today is managing conflicts of interest for nonprofit directors. So a few housekeeping items just before we start. For those listening live on GoToWebinar, you can download a copy of the slides for today's presentation under the Handouts tab on your GoToWebinar client. You'll see a bunch of sort of vertical tabs. There's a little arrow under Handouts. It'll create a drop-down menu, and you can download the slides there. The GoToWebinar client also has a field where you can type in questions during the presentation. I will try to answer questions at the end of the presentation, time permitting, although we have a good amount of material to get through today. If I don't get to your question, my email address will be on the final slide. So feel free to email your questions over and I'll be happy to chat with you. So before we start on the substance of today's webinar, just a few notes about us at the DC Bar Pro Bono Center. Our nonprofit legal assistance program matches DC nonprofit organizations with pro bono legal counsel. Volunteer attorneys can help your nonprofit with many different types of matters, including corporate governance, IRS compliance, employment law, real estate, etc. We also host in-person legal clinics to address specific topics. We actually have one coming up in June about governance policies, and I'll give you a bit of a plug for that one at the end. We sponsor trainings, webinars, and podcasts regarding legal issues relevant to nonprofits, like today's presentation. And we provide written resources and an archive of all our past training sessions, webinars, resource guides, etc. On our website, which is lawhelp.org/DC/CED. I mentioned that today's webinar is part of our Board Basics webinar series. We have a number of other Board Basic webinars archived on the website that you can check out. Stuff about calling and conducting board meetings, taking board minutes, board voting, voting by unanimous written consent, a lot of stuff about board committees. So I encourage you to check out that part of our website specifically if you are on a nonprofit board. So, okay, let's start with conflicts of interest, today's topic. It's a really interesting topic. It's one that I get really excited about and other lawyers get excited about. It's something that affects all nonprofits, so there's a universality to this topic. And I want to say off the bat that I'm going to be quoting a lot of IRS language throughout the presentation. The slides are going to be a little text heavy. For relative to what I like to do, but there's a few reasons for that. First, this is an area where the IRS has a lot to say, so why not get it from the source instead of from me? So I want to put some relevant IRS language up on the screen. And second, I want these slides to be a resource for you in the future going forward, or something that you can circulate to other members of your board or within your organizations. So the slides themselves are meant to be a useful resource. Okay, let's start with some definitions. What is a conflict of interest? So here's an IRS definition. A conflict of interest arises when a person in a position of authority over an organization, such as a director, officer, or manager, may benefit personally from a decision he or she could make. I really like this definition. I think it's clear, it's concise. Another one that we get out of the sample IRS conflict of interest policy. Conflicts of interest are a transaction or arrangement that might benefit the private interest of an officer or director of the organization, or might result in a possible excess benefit transaction. And we will talk about what that means. We'll go over some of that terminology as we move through the presentation today. I want to make some points before we go any further. So a conflict of interest can involve both financial and non-financial interests. So, for example, reputational or publicity value is something that we should think about. So let's say we have a neighborhood nonprofit that holds a gala every year where they honor small businesses that have contributed to the community. And I'm on the board, but I also own a local bakery that is being considered for an award. It would be a conflict of interest for me to participate in that selection process and in that voting process for that award, even though there's no money on the line. the reputational and sort of publicity benefits of that are a material non-financial benefit that we should also be concerned about. On this point, something that I hear quite common is people say, well, many people serve on nonprofit boards because, directly or indirectly, it enhances their reputation or their standing in the community. Is that a problem? Am I getting an impermissible non-financial benefit? And the answer is generally no, because when we're talking about conflicts of interest, we're usually talking about specific transactions. So we're talking about specific decisions that the board is making, which may or may not intersect with your own private interests. These sort of high-level reputational benefits that kind of stem from board service organically are not within the scope of what we're concerned about today. We're talking about benefits that are linked to specific transactions that the nonprofit is considering taking. Another point is that benefits can be either direct or indirect. So direct benefit means, it flows directly to me, the director or officer or other manager of the organization. Indirect benefits can be benefits that flow to a related business that I own or that I have an interest in. They can also be benefits that flow to my family members. And the IRS has a pretty broad definition of family members. It includes spouses, ancestors, brothers and sisters, children, grandchildren, great-grandchildren, and the spouses of brothers, sisters, children, grandchildren, or great-grandchildren. So if my nonprofit is looking to lease some new office space and one of the potential offices is owned by my spouse's brother, then that is within the scope of this sort of family interest, and I should be concerned about and disclosing that potential conflict. But that sort of leads me to this last point, which is, I want to make clear that conflicts of interest or potential conflicts of interest are not inherently illegal, unethical, or prohibited, and transactions involving conflicts of interest can ultimately be approved, but they have to be appropriately managed. And that's going to be the focus of today's webinar. We're going to talk about how we kind of spot and define conflicts. We're going to talk about what legal authorities are relevant to conflicts of interest. And we're also going to talk about what steps you can take to manage those conflicts. And a key one there is adopting and implementing an effective conflicts of interest policy. With all that being said, I also want to note, so before we move on, let's talk about some potential conflicts. So let's flesh this out. So the first one, the sort of classic example, is when an officer, director, or trustee votes on a contract between the organization, between the nonprofit, and a business that is owned by that same officer, director, or trustee. Kind of classic, I own an accounting firm, and our nonprofit is looking for an accountant, and I put up my firm as a potential vendor or potential service provider, and that is a potential conflict of interest. Another example is when an officer, director, or trustee votes on a contract between the nonprofit and a business that I have an ownership or stake or other interest in. So a little bit more abstracted. I don't own the business maybe, but I have some sort of stake in it. Maybe I have stock in the business. Maybe I'm an employee or manager of that business. So even if I'm not the owner, if I have some sort of ownership stake or interest in that entity, that presents a conflict of interest. Still pretty straightforward. Third example is when an officer, director, or trustee votes on their own compensation as a staff member of the organization, or the compensation of an individual that is related to that officer, director, or trustee. So if I'm on the board and it just so happens that my sister's husband is the CEO, voting on that individual's compensation presents a conflict. Okay, another example, when an officer, director, or trustee votes on a partnership between the nonprofit and another organization on which they are closely affiliated. So if I am on the board of another organization, or if I have an ownership stake in another organization, so potential partnerships or collaborations or just other relationships between those two organizations, that can present a potential conflict. And then finally, this one's interesting, when an officer, director, or trustee is also a constituent of the nonprofit itself. and votes on substantive or programmatic matters which affect them indirectly or directly. An example here that I see sometimes are sort of PTA groups that are organized as nonprofits, where the parents are on the board but might also have students at the school during their board tenure, and they are voting on matters which could affect their own children. Voting to approve fundraising for a school band trip to Australia that my child just so happens to be interested in going on. That can present a conflict, and that can give heartburn to a lot of organizations because you may have a lot of constituents on your board. It might be a great practice to do so, but just want to flag that presents a lot of opportunities for potential conflicts that should be sensitively and appropriately managed. And I want to this is certainly not an exhaustive list. When we're thinking about conflicts of interest, we want to think creatively, and we want to think laterally, and we want to think very critically. Okay. Okay. So this is a point that I wanted to make, that today we're going to focus on legal authorities and the law around conflict of interest, but this is certainly not just a legal matter. Conflicts can damage your organization's reputation and credibility and standing vis-a-vis your donors, partners, government bodies, your constituents, and the general public. High-profile regional and national scandals involving nonprofits and conflicts of interest have, in recent years, raised public awareness and sensitivity around conflicts of interest. So regionally, we've been rocked by a lot of conflict of interest scandals, a lot involving nonprofit hospital systems where board members were also affiliated with pharmaceutical or medical supply companies that did business with the hospitals. That's something that's definitely floating around out here in the DMV. Nationally, I mean, a big story related to the current presidential administration has to do with the Trump Foundation and, as alleged by the New York Attorney General, the use of foundation funds to advance the president's personal interests. So conflicts of interest are front page news nowadays. There's sort of this moral outrage that you feel when you have this nonprofit that's supposed to be organized for the public, that's accepting donations, and that become a vehicle for sort of self-interest or self-dealing. So, we're going to talk about a lot about the law today, but there are a lot of other reasons to be concerned about conflicts of interest. So let's get to the law. Okay, so first I want to step back and talk about how this whole conversation about conflicts of interest intersects with your fiduciary duties as a nonprofit director. Serving on the board of a nonprofit means that directors and officers owe what we call fiduciary duties to the nonprofit. These are legally recognized and enforceable duties under state and federal law. In DC, we recognize fiduciary duties of care, loyalty, obedience, and something we call a duty to inform. Managing conflicts of interest is integral to satisfying the director's duty of loyalty, and the IRS has some words on this. The directors of a charity owe it a duty of loyalty. The duty of loyalty requires the director to act in the interest of the charity rather than in the personal interest of the director or some other person or organization. In particular, the duty of loyalty requires the director to avoid conflicts of interest that are detrimental to the charity. These fiduciary duties are not the only kind of legal concepts that we have floating around. There are a lot of rules and concepts that stem from the IRS itself, from the agency's regulations, or from the Internal Revenue Code, which is the governing statute for 501c3s and for the agency in the nonprofit area. So let's zoom back out and set the stage for that. So 501c3 nonprofits receive favorable tax treatment, and donations to 501c3s are subsidized by the public vis-a-vis tax deductions that we allow the donors to take. So as a result, under the Internal Revenue Code, 501c3s are subject to stricter rules and must be organized and operated for the public's benefit. And two concepts that flow out of that are, first of all, there's a prohibition on what we call private benefit. So a Section 501c3 organization must not be organized or operated for the benefit of private interests. And there's a whole list of private persons, but that's sort of a general prohibition or a general concept. And there's a slightly more kind of specific prohibition, no part of the net earnings of a 501c3 organization may inure to the benefit of any private shareholder or individual. And we call this the prohibition on private inurement. It's a little bit more specific because we're specifically talking about net earnings. And so we're specifically talking about financial benefits in this context. So for a 501c3, private individuals cannot reap financial benefits off the net earnings of a 501c3. There's another related concept here called excess benefit transaction. So private inurement is often accomplished through what the IRS calls an excess benefit transaction and are therefore heavily scrutinized by the IRS. An excess benefit transaction is defined by the IRS as a transaction between a so-called disqualified person and a nonprofit where the nonprofit directly or indirectly provides the disqualified person with an economic benefit, the value of which exceeds the value of the consideration received by the nonprofit in return. You can tell that was written by a lawyer. And in real people talk, this just means overpaying certain insiders for goods or services or other means. And that overpayment, the value that you pay over what the fair or market value was, that's the excess benefit. There's another term there, disqualified person. That's a little funny. A disqualified person is defined as an individual or entity who is in a position to exercise substantial influence over the affairs of the nonprofit anytime during the 5 years preceding the transaction in question. So this can include your directors of the board, include your C-suite executives and other key officers, and it includes any other person who has substantial managerial authority over the nonprofit, regardless of their form or title. This also includes family members of these individuals who exercise substantial influence, and it also includes entities controlled by individuals who exercise substantial influence and their families. So that's a pretty wide net. Just the takeaway here is that when it comes to excess benefit transactions, if you overpay the leaders of your organization or family members or entities associated with those leaders, that can cause a lot of trouble. And that trouble comes in the form of what we call intermediate sanctions. So these are penalties which apply to organizations and disqualified persons who both receive and authorize excess benefit transactions. The penalties, they're called intermediate penalties because they are not as serious as terminating your organization's 501c3 status. Back in the day, before we invented intermediate sanctions, that was the IRS's only recourse when excess benefit transactions occurred. Now we just get to levy excise taxes that we call intermediate sanctions. And so for those who receive an excess benefit, that individual must pay a penalty equal to 25% of the value of the excess benefit that they received. They must also return or correct the value of the excess benefit itself, or else they have to pay an additional 200% excise tax on the value of those benefits. Now, here's what's interesting. On directors and managers who knowingly approved the excess benefit transaction, they also have to pay an excise tax equal to the lesser of $20,000 or 10% the value of the excess benefit. So the takeaway here is that directors and managers, so y'all here on the webinar, can be personally liable for approving excess benefit transactions. And how this connects to our conversation about conflicts of interest is that excess benefit transactions often arise because conflicts of interest were not effectively managed. Excess benefit transactions are much less likely to occur when conflicted individuals are excluded from decision making on those areas. But I do want to note that you can violate the private benefit and private inurement rules without imparting an excess benefit. Even paying market rate for goods and services is problematic if the conflicted individuals participated in or approved the transaction and were not properly treated under your conflict of interest policy. And we'll talk about how to do that. But when it comes to excess benefits, we have these intermediate sanctions, and it's a very serious matter. The last sort of point about federal law that I want to make is that conflict of interest is something that is addressed in the 990 for those who file the full Form 990. Part 6 of the 990 requires a nonprofit to answer questions regarding its conflict of interest policies and procedures. Does the organization have a written conflict of interest policy? Are officers, directors, trustees, and key employees required to annually disclose their interests that could give rise to conflicts? And does the organization regularly and consistently monitor and enforce compliance with the policy? And if yes, you actually have to describe how you do that. So this is the IRS giving you a very, very strong wink, wink, nudge, nudge that these are steps that you should be taking to have the best governance practices for your organization. The 990 also asks about other conflict of interest related topics, including what specific transactions occurred between the organization and people with leadership roles within the organization. It asks about details regarding executive compensation and how executive compensation was set. And it asks about the independence of board members and about relationships between members of the board. And we'll touch on all these topics in a moment. And finally, and I won't go into too much detail about this, but at the state or local level, the DC Nonprofit Code also addresses what it calls conflicting interest transactions. And essentially, per the code, a transaction between a nonprofit and its own officers and directors can be deemed void or voidable unless the interested director discloses the potential conflict and the disinterested directors make an affirmative vote to approve that transaction, which is essentially the same requirements under the IRS and per the IRS template conflict of interest policy. So the takeaway here is that satisfying the IRS requirements and using IRS approved conflict of interest policies will also put you in a good spot with respect to the DC local rules regarding conflict of interest. Okay, so we've teased it for long enough. Let's move on and talk about conflict of interest policies. I like this language from the IRS describing what the purpose of a conflict of interest policy for. The IRS says that they're intended to help ensure that when actual or potential conflicts of interest arise, the organization has a process in place under which affected individuals will advise the board about all the relevant facts concerning the situation, and then have a process under which those individuals will be excused from voting on such matters. This echoes what I said a moment ago. It's this regime of disclosure and exclusion, and that's how we manage conflicts of interest. Having a conflict of interest policy isn't legally required. However, the IRS considers such policies and procedures to improve tax compliance. The absence of appropriate policies per the IRS can lead to opportunities for excess benefit transactions, private inurement, operation for non-exempt purposes, or other activities inconsistent with tax-exempt status. So not having a conflict of interest policy is a huge red flag for the IRS and can increase your audit risk with the agency. So conflict of interest policies that are heavily encouraged. Every nonprofit should have one. Your nonprofit should have one. So let's dive into the anatomy of a conflict of interest policy. At the very end of the presentation, I'll have a link where you can download a template conflict of interest policy that we've created here at the DC Bar Pro Bono Center. It is substantially identical to the IRS's template conflict of interest policy. We've kind of enhanced it in a couple little spots that I'll talk about. So, if you want a link to a template policy, you'll see that at the last slide. Okay, anatomy of conflict of interest policy. The first thing we want to think about is defining who the individuals are that are covered under the policy. So your conflict of interest policy should cover directors, officers, key employees, and their families. Key employees are actually not included on the IRS's sample conflict of interest policy, but we think they should be included because if you go back a few slides, the Form 990 asks if they're included on your conflict of interest policy. Also, as we've sort of touched on, the excess benefit rules cover high-level managers even if they aren't officers, directors, or trustees. So the excess benefit rules can extend to affect your key employees, so we may as well include them in the scope of our conflict of interest policy. Now, organizations can define the term key employee in different ways, but you should generally include your highest compensated individuals, people with managerial responsibility over the entire organization or over significant segments of the organization, and those with the authority to control the finances of the organization, including capital budgets, operating budgets, and employee compensation. These are generally people who are going to be considered key employees. Going to that idea about family members, our sample policy expands the definition of family members, which I showed you up in the kind of first few slides, a little bit beyond the IRS definition to also include people living together in the same household. This recognizes that a board member could theoretically make a decision to benefit their unmarried romantic partner or domestic partner, or their boyfriend, girlfriend, whatever, and we want that to be within the scope of this policy. So just because they're not married doesn't mean that conflicts can't arise in those areas. Sorry, I'm just poking through the questions as we move along. I know I would save them to the end, but if we have particularly germane ones, I do want to touch on them while we're going. Okay, let's keep moving and we'll save questions to the end. So the second thing we want to think about is defining what a conflict of interest is. A conflict of interest policy should define the scope of financial interests that are covered, and the scope should be broad. It should include when a covered individual has an ownership or investment interest in an entity with which the nonprofit is doing business. Again, this is the classic example. It's I own an HVAC renovation company. Our nonprofit needs to renovate the HVAC in its building. If the nonprofit wants to use my company, that could be a potential conflict. It also covers when an individual receives remuneration, including non-insubstantial gifts or favors from any entity or individual with which the organization is doing business. I mean, we should think about this from the IRS's perspective. They're going to be very critical. They've seen everything. So, let's say I own an accounting firm and my friend is the director of a nonprofit. And I say, hey, I'll do your taxes for free if you can sort of convince your nonprofit to hire us as their accounting firm. That kind of relationship, that kind of deal should be within the scope of your conflict of interest policy, even if it doesn't really involve an entity that the director themselves owns. And finally, it should include when a covered individual has a potential ownership or investment interest in an entity or individual with which the organization is negotiating a transaction. So this just bumps the timeline up a little bit more. As soon as you kind of start considering or negotiating a transaction, that should be enough to give rise to a potential conflict and kind of trigger this process of disclosure and exclusion for the potentially conflicted individual. Okay, so moving on, let's talk about disclosure. So your conflict of interest policy should establish a duty to disclose. It should require covered entities to affirmatively disclose all potential conflicts. Disclosing a potential conflict, as we've talked about, doesn't mean that the transaction is automatically prohibited, but it does give the disinterested directors an opportunity to analyze, deliberate, and approve the transaction if appropriate. To allow the board to perform this critical function, we have to disclose all potential conflicts. So it's important to create a culture of disclosure and transparency at your organization. You should disclose even when there's the appearance of a conflict, and then you let the board decide if the conflict A really exists, and B, if it's of the nature that makes the transaction an impermissible transaction. If folks walk away from today's webinar over disclosing potential conflicts, then I will not lose any sleep. That's mission accomplished. We want to create a culture where all potential conflicts are disclosed, and then just let the disinterested directors decide what to do with it. And also, we want to disclose early. We mentioned this. We want to disclose as soon as the board begins to consider or negotiate a potentially conflicted transaction. You don't want to put in all the work and time of approving a new vendor or going through some sort of partnership process, and then halfway through, it's like, oh, by the way, my spouse owns that company, and we should have never have had me voting on this matter. So disclose as early as possible. After disclosure, what do? We have to manage and approve the transaction in light of the disclosure. So the remaining, what we call disinterested directors, should then conduct due diligence to determine if the transaction is still in the best interest of the organization, and they should look into alternatives to the proposed transaction that may be more advantageous and that don't present a conflict. So when it comes to goods or services, the board should get competing quotes or do some research about alternative providers, and so that they have some data, so they have some information about whether they're getting a good deal through the conflicted individual. The interested person can make a presentation or provide information, but they should not participate in the subsequent discussion or vote. If a more advantageous transaction is not reasonably available, the directors can then determine by a majority vote whether the transaction is in the organization's best interest, is for its own benefit, and that it's fair and reasonable. Formally, you do that by by a recorded vote of a majority of the disinterested directors. And so there's some concepts there at play, organization's best interest, own benefit, fair and reasonable. Getting a good financial deal isn't good enough. It's got to be something that the organization really needs for its operations, something that really advances the organization's mission. It doesn't matter if $20,000 is a really good deal for a 6-foot-tall portrait of your founder. If your nonprofit doesn't need that portrait, it shouldn't be paying for it. And so, or let's think about an example that our former director liked to use was interior design services. Even if you get a really good deal on interior design services, if you weren't in the market for interior design services, and your director who owns an interior design firm is volunteering to just give you a really good deal, that's not a good enough reason to approve the transaction. And it's going to raise suspicion on the part of the IRS if you're buying services that you don't need from someone who has some sort of affiliation or standing within your organization. Record keeping is an important part of this whole process. Generally, nonprofits should not be taking overly detailed meeting minutes. It's usually enough to just record what happened at the board meeting, and not what was specifically said or discussed at a more granular level. Your meeting minutes should not be a transcript of your meeting. Doing that, it does not advance sort of the purposes of having meeting minutes, and it can actually put your organization, it can increase liability for the organization. We have a whole webinar on taking meeting minutes that I encourage folks to check out if this isn't a topic that they've thought about in a little while. With all that said, conflict of interest related transactions are an exception. The minutes for a conflict of interest related discussion should be much more detailed so that you can capture the board's efforts to effectively analyze and manage potential conflicts. This is to cover your butt. This is if you ever find yourself in a defensive position, if you're being audited by the IRS, you want to be able to produce records that show that you appropriately and effectively managed the potential conflicts of interest. So your conflict of interest policy should require your meeting minutes to include the names of people who disclosed or were found to have a conflicting interest, the nature of that conflicting interest, the names of the people who were present for discussion and votes relating to the transaction. And if you asked the conflicted people to leave, you should make a record that you did that and that they were excluded. The content of the subsequent discussion, including records of any alternatives to the proposed transaction that were considered. The board or committee's ultimate decision as to whether an inappropriate conflict of interest actually existed, and finally, a record of any votes taken in connection with the proceedings. So much more detailed minutes in order to protect you and the organization in case there's any scrutiny around a potentially conflicted transaction. Finally, we should note that to carry any weight, the IRS requires minutes to be prepared contemporaneously, and its definition of contemporaneously is the later of 60 days or the date of the next board meeting. So a little note there about minutes. Okay, so we've talked about the policy. Now there's some practices surrounding the policy that we also want to talk about. In addition to providing and reviewing your conflict of interest policy with new directors, the IRS wants all organizations to renew their policy on an annual basis with all covered persons. And the sample IRS policy actually has a little affirmation that covered persons are supposed to sign every year, which affirms that they received a copy of the policy, that they read and understand the policy, that they agree to comply with the policy, and that they understand that the organization is a charity and, as such, must engage primarily in activities that accomplish one or more of its tax-exempt purposes. That last bit really isn't directly related to conflict of interest policies, but it's a good thing to hammer in whenever we get an opportunity to for the board. Something else you might have heard about, and another best practice that we recommend, is to have annual conflict of interest disclosure forms. The Form 990 asks whether officers, directors, and key employees are required to provide annual disclosures of interest that could potentially give rise to a conflict. So when we're talking about disclosure, we're kind of in a reactive position. We're looking at something that's actually happening, and we're raising our hand and saying, hey, I have a potential conflict here. With annual disclosures, we're looking prospectively. We're looking at potential conflicts that might not be affirmatively disclosed during a board meeting. Or let's say you're considering a transaction and a board member isn't at the meeting. You know, they had to skip the meeting. We want some mechanism to know if this transaction that we're considering might conflict with their own private interests, even if they're not in the room. So the sample disclosure form that we get from the IRS asks individuals to disclose any relationships, transactions, positions, or circumstances that you believe could contribute to an actual or possible conflict of interest between the organization and your personal interests, financial or otherwise. And then the person just goes and lists everything they can think of that could potentially cause a conflict. The disclosures also ask people to disclose any actual transactions that they're aware of between the nonprofit and entities or people with which they have a business, investment, or family relationship. So just in case these conflicts have not been sussed out organically through disclosure kind of ad hoc, this is a chance to kind of go back and make sure that we have all of those on the record. You should also be disclosing other nonprofit or for-profit boards on which they or their immediate family sit, serve as an officer, are a majority shareholder, or that they own. And you'll also be disclosing the name of their current employer. So, you know, this is an exercise to get an inventory of people and organizations that our board have relationships with and that we should be extremely careful and sensitive around if we are ever interacting with those entities. Okay, so there's a special circumstance that I want to spend some time on, and that is the question of executive compensation. Again, this is another one of those conflict of interest related matters that the IRS asks about on the 990. Executive compensation is a high risk area for conflict of interest violations and for excess benefit transactions. So that makes them a prime IRS enforcement target. The concern is that nonprofits will pay executives excessive compensation through salaries, benefits, any other sort of compensation package, and that excessive compensation will be approved by the executives themselves and or conflicted board members. So to help nonprofits, the Internal Revenue Code contains a so-called safe harbor for setting executive compensation. If the nonprofit follows some specific requirements, then the burden shifts to the IRS to prove that the nonprofit's compensation was unreasonable. Otherwise, nonprofits are on the defensive. They always have to be proving that their compensation is reasonable. But by following these sort of procedural guidelines, you create what's called a rebuttable presumption that your compensation is reasonable and not excessive. The safe harbor tracks closely with principles contained in the sample conflict of interest policy, so they're related concepts. And as I mentioned, this is something that the Form 990 asks about. It asks specifically whether you follow the safe harbor when setting the CEO's compensation and to describe your process. So let me quickly outline what that process looks like. The compensation safe harbor has 4 elements. You need prior approval, you have to have no conflicts of interest, you have to rely on adequate data, and you have to have adequate documentation. So let's go over those elements. First, prior approval. Compensation must be approved in advance by an authorized body. That authorized body is typically the board, or it could be a board committee. Some organizations split off a separate compensation committee, or you might do it with your executive committee. That sort of depends on how your board is structured and what your organization looks like. If you're doing a board committee, remember they can only be made up of board members. Non-board members can advise the committee, but they cannot be appointed to it or vote on it. This is a principle that extends to all board committees, not just compensation committees. But if you have a board committee that has the power to vote on final board level actions, that can only be comprised of board members. No non-directors on your board level committees. Something we're always kind of hammering home. The second point is that there can be no conflicts on that body. So no person voting on compensation of a disqualified person may be a family member of that person, be in a position to benefit financially if the compensation is approved or disapproved, work under that disqualified person, be an employee whose compensation is subject to approval by that person, or be involved in any financial transaction with the organization that is subject to the disqualified person's approval. It looks like there's a lot of moving parts there, but it's all the same general idea. We don't want anyone voting on an executive's compensation if they have any skin in the game, if they have anything to gain or lose from how much that compensation is set. Again, thinking from the IRS's perspective, we want to avoid kind of sweetheart deals where a board member, let's say, agrees to approve a CEO's sort of wackadoodle excessive compensation, and then the CEO in turn agrees to hire that person's company or agrees to approve their compensation on a separate nonprofit where they're on the board. You know, and you can sort of spin that out into a lot of different scenarios. So we want everyone to be disinterested from a personal perspective in the compensation of that executive. That third point is reliance on adequate data. So the board should rely on information that establishes the comparability of their compensation compared to peer organizations or organizations in their peer group. This is sort of the meat of the analysis. Peer organizations can be based on mission, sector, budget size, and geography. And then the data that you use can be drawn from 990s. There are a lot of compensation surveys out there floating around. And in some cases, information about pay from for-profit businesses can also be relevant to your executive pay program. Say you have professionals like lawyers or doctors working in your organization. That's an example where you don't only have to look at the nonprofit sphere. It might be relevant to broaden out your data from also the private sector. Larger organizations may and often do engage a consultant to evaluate executive pay, establish their peer group, sort through the compensation surveys, and generally assist with their compensation program design. We have some guidance that for smaller organizations with annual revenue of less than 1 million, that they can use 3 comparable organizations and that they can draw their information from public returns from 990s. Okay, and then the last point is that you have to have adequate documentation. So the documentation of your compensation decisions and your process should include the date of approval, the specific amount that you landed on, the names and roles of the decision makers, identification of the information relied upon to make your decisions, so your comparability information, and information about specific conflicts of interest and how they were resolved. So did you make sure that you asked folks to disclose conflicts? Did you exclude people who disclosed conflicts, et cetera, et cetera. Okay, so that's executive compensation. All right, and organizations to benefit from the safe harbor should be properly reporting the compensation on their 990s and on W-2s. Another sort of special interesting circumstance that's related to conflict of interest is this idea, it's this concept called usurpation of corporate opportunities. The corporate opportunity doctrine is connected to the duty of loyalty, and it's something that's addressed in the DC Nonprofit Code. What it means, essentially, is that when a board member is presented with a business opportunity that he or she knows or reasonably should know would be of interest to the organization, the board member must first disclose that opportunity to the nonprofit and give the disinterested directors an opportunity to decide whether the organization should act on the opportunity. So the organization always gets the first bite at the apple. Let's say I own a company that's looking to lease some office space, and just it so happens at the same time the nonprofit that I sit on the board of is looking for very similar office space, and I find a listing for some great office space at a really good price. Under the corporate opportunity doctrine, I should be disclosing that listing to the nonprofit first, give the disinterested directors an opportunity to decide whether they want to take it, and then only after they make that decision can I, and if they say no, then I can act on that opportunity. It doesn't matter whether I learn about that opportunity through my position with the organization or just in my day-to-day non-board life. And again, if the organization declines the opportunity, then I can take advantage of it. So an interesting little doctrine to be aware of. Something else I wanted to mention is sitting on multiple boards. Now, generally, a conflict of interest doesn't include when a person sits on multiple boards, and when doing so does not involve a material interest of or benefit to such persons. So, for example, if you belong on 2 nonprofit boards, there's generally no conflict of interest if you solicit a donation for one organization and don't solicit it for another. That's just you exercising your duties as a board member. There's no money going to your pocket. There's no kind of personal interest in that. We recognize that that's a time-consuming and difficult situation to be in, and generally speaking, there's not going to be conflicts of interest that come out of just the fact that you're on 2 boards at the same time. However, there are definitely situations that could directly involve both organizations in either a competitive or a collaborative kind of dynamic, and those could give rise to potential conflicts. And sort of the takeaway there is that, when in doubt, just disclose to the board. That should be the takeaway from this whole presentation, really. When in doubt, disclose to the uninterested directors, let them decide if this is something that you should be excluded from or something that the organization can't move forward with because of potential conflicts. So, let's say let's say you're on the board of 2 organizations, and they're involved in some sort of collaboration agreement. Just disclose that. That might not be a big deal, but if things start to get complicated, or if conflicts do start to arise from that relationship, the board should know that you're wearing both hats, that you're on both boards. If your organizations are kind of on the same sector and you might be competing for grants or for other kinds of funding, definitely disclose that, because there could be situations where it's sort of a zero-sum game with the grant, and you don't want to be in a position where you're helping the organization get a grant that your other organization also wants to get, or vice versa. Finally, that there might be kind of issue conflicts between the organizations. If your one organization takes kind of a policy stance or kind of a programmatic direction that's kind of just inherently and directly at odds with the other organization, that's not a financial kind of conflict, but that is a issue conflict. It's almost a kind of mission conflict that folks should be aware of, and that you might have to manage. Okay, and then another concept, kind of our last big juicy concept, is something called director independence. So on the 990, the IRS wants to know whether your nonprofit board is composed of so-called independent directors. And these are directors that A, have not been compensated as an officer or employee of the organization or a legally related organization, or has been compensated over $10,000 as an independent contractor, and the individual cannot have been involved personally or had a family member involved in a transaction with the organization or a legally related organization worth more than $100,000 in the aggregate, or the greater of either $10,000 or 1% of the organization's revenue in a single transaction. Kind of clunky there, but that's the standard. Basically, we want directors on boards to not have these sorts of financial or employment-like relationships with the organization itself. That second point, that you should be thinking, oh, that's a conflict of interest transaction. Yes, even if these transactions have been approved through the organization's conflict of interest process, when we're talking about figuring out who's independent or not, it doesn't really matter. If you're a board member who has been engaged in sort of high-value transactions with the nonprofit, you're not going to be considered, quote unquote, an independent director. The IRS also wants to know about whether any officers, directors, trustees, or employees have family or business relationships with other officers, directors, trustees, or key employees. The sort of gist here is that the IRS believes that having independent and unrelated board members is important for managing conflicts of interest and for protecting the organization against private inurement and excess benefit transactions. So this is another area, just like with our governance policies, where it's a red flag for the IRS if too many members of your board are not independent, or if there are too many familial or business relationships between members of your board. That can be a signal to the IRS that there's a risk of private inurement, conflicts of interest, excess benefit transactions, et cetera, et cetera. So as a best practice, you should strive to have at least a majority, and ideally a substantial majority, over 2/3 of board members, be independent and unrelated to each other. That's sort of a final point that comes up on the 990 and that overlaps with this conversation about conflicts of interest. So finally, this is our last slide, some takeaways, some coming back full circle. First of all, you should definitely adopt a conflict of interest policy. You should ensure that your board members receive the policy, that they acknowledge the receipt, that they read it, and that that on an annual basis they affirm that they've done all these things. Do your annual review. You should review your COI policy and discuss your procedures at board meetings. So, we talked about getting that little signed form once a year, but it's also a best practice, very helpful, very important to actually talk about conflicts of interest at board meetings. Maybe the meeting where you ask everyone to give their annual disclosure form, that's also a good opportunity to kind of sit together, talk about what conflicts of interest are, make sure everyone's on the same page with respect to how everyone should be disclosing and managing their potential conflicts. You should fill out your annual disclosure forms. We've talked about those. You should train board members on their duty to disclose, and you should create a culture of disclosure and transparency. That's a tone at the top kind of issue, by the way. I think it's so powerful and important for the leaders of the organization, for your board presidents, to show people what it's like to disclose potential conflicts, and to do it kind of often, and to model the kind of disclosure and transparency that you want to see in the rest of the organization. Okay, number 6, ask people to disclose potential conflicts when considering new transactions. So this is kind of a practical point. If we're at a board meeting and we're talking about a potential partnership or vendor or contractor or something else, the person running the meeting or the person running that segment should ask, okay, now let's take a minute. If anyone here in the room has a potential conflict or thinks that they might have a conflict going forward, now's your opportunity to raise your hand and to disclose that conflict. So don't just make disclosure kind of an abstract norm that everyone's supposed to do. Actually make space during your board meetings to give people a chance to disclose conflicts if it's the kind of topic that could be sensitive or that could be affected by conflicts. Appropriately manage conflicts that you become aware of and make appropriate records, of course. Take advantage of the safe harbor procedure when it comes to executive compensation. And finally, strive to maintain a substantial majority of independent and unrelated directors on the board. So that's sort of a summary of everything we've talked about today. This is my contact info. I'm at jqu@dcbar.org, and I wanted to leave you with some resources. So we have that general nonprofit resource library. We have a whole section of our library about serving on the board of directors that has those other board basics webinars on it. We have a legal alert that's just about conflict of interest policies with a sample policy and sample disclosure form. Again, those are based largely on the IRS policies, but we've enhanced them in a couple of ways. We have added that language about key employees, and we've added that language about people living together in the same household being included in the definition of family members, for example. And finally, I wanted to plug an event that we maybe haven't even officially announced yet, so you'll get the first bite at the apple. It is our annual IRS Recommended Governance Policies Clinic. At this clinic, you can come and meet in person with an attorney, and the attorneys will help you draft, review, and or update all 3 of the IRS recommended governance policies. So today we've been talking about conflict of interest policies. That's definitely included, but the clinic will also get you a whistleblower and a record retention policy. Those are the other 2 policies that the IRS asks about on the Form 990 as a sort of wink, wink, nudge, nudge. You should probably have these policies kind of thing. So this is the clinic where you can go, learn about what these policies are, adopt them if you don't have them, review them if you do have them, and talk with an attorney about specific questions you might have about interpreting and implementing those policies in your organization. That is going to be happening the morning of June 26th, and there's a link there for the registration page where you can go and register for the clinic. Okay, great. So we have a couple extra minutes. As I mentioned at the top, if folks missed it, there is a field on your GoToWebinar client where you can ask questions, and I'm going to see if we can do a few before we have to log off. Okay, so when we talked about excess benefit transactions, I mentioned that these intermediate sanctions, those excise taxes, can be levied on directors and managers who knowingly approved the excess benefit transaction. We have a question here, if the beneficiary of the transaction didn't disclose their interest, how much effort do decision makers have to exert to meet the due diligence requirements? I mean, that's a really good point. If a person has hidden their personal interest from you and you did not knowingly or willfully approve the transaction with that information in mind, then that is going to be a really helpful fact and might protect you from liability. But this is going to be very fact sensitive. But if you really should have known that a director was conflicted, if there were signals or red flags or signs that that this could be either a conflicted situation or that the benefit itself was excessive, that could be something else that you didn't know about. It's like, oh, I didn't know I was overpaying. I had no idea what the market price was in the first place. Ignorance cannot be a total defense. If you didn't do your due diligence and ask the basic questions to kind of unearth what's going on, or if you know that your organization doesn't have a process for sussing out and kind of effectively detecting conflicts of interest, then it's not a guarantee, but I think the IRS could use that as an argument for why you should be found personally liable. It's not a black and white world. We should think about this as like, what's going to increase my risk and what's going to decrease it. If you're at the kind of organization where you're not effectively managing conflicts of interest and you're not effectively investigating whether payments are excess benefit transactions, you should be treading very carefully and maybe not voting willy-nilly on everything that the organization does. We have a question here about whether covered individuals under a conflict of interest policy could include volunteers of membership organizations. So there's a few moving parts to that. First of all, when we talk about membership organizations, there are legally recognized membership organizations, which means that in your articles and your bylaws, you say you are a membership organization and you have a body of people known as members who have some control over the governance of the organization. For example, they elect the members of the board of directors, not the board itself. That is a legally speaking a membership organization. If you are one of those, if those folks have sort of managerial responsibilities, I mean, some organizations are all volunteer organizations. Definitely the people, the highest level managers of those sorts of organizations are themselves volunteers. So it is possible to have volunteers falling under the scope of a conflict of interest policy. I've also seen conflict of interest disclosure forms, those annual disclosures. I have seen those as including volunteers. So asking sort of key volunteers or all your volunteers, depending on how practical that is, to disclose organizations that they're affiliated with so that the board doesn't get into potential conflicts. So yeah, it is possible for volunteers to be within the scope of a conflict of interest policy. Will there be a recording of this available afterwards? Yeah, we're going to post this webinar up on our website under our resources page. Sorry, one moment. Okay, so let's see. If an organization's bylaws permit deliberation or voting through email or electronic means, how do you balance the legal requirement to disclose material information to board members with board members that are conflicted? So that's a good question. Okay, so you can have your meetings electronically, like through teleconference or through the phone. Those meetings are treated the same as in-person meetings under DC law, and so these conflict of interest procedures are going to be more or less the same. If someone discloses a conflict, they can, over the phone or over the video conference, tell the folks on the line all the material information and then leave the conversation. They can physically drop off the line. They should not be contributing to the subsequent discussion or to the vote on the matter. Voting over email is a different issue. In DC, there's only one way to vote over email, and it's something we call unanimous written consent. These are matters where someone sends out sort of a proposal or a resolution or some sort of action via email, and then all the other directors on the board, 100%, if you have an 11-person board, all 11 board members email back agreeing affirmatively to the action. If you do that, then the action can pass via email. If even one person does not, cannot, they abstain, they say no, whatever, then you have to, if you still want to pass that kind of action, you have to do it at a meeting, which, by the way, can include over the phone or video conference or something, but it just means that you have to do it in a meeting. So in that case, if someone has a conflict, they should be disclosing that they have the conflict, and then you can't do the unanimous written consent. You would have to manage that conflict before you were able to have that vote. So unanimous written consent is not designed for transactions where there are potential conflicts. They're really designed for the things that are so non-controversial that you can literally get 100% of the board members to agree to it. That's why it's like an exception to the rule, but the default rule is that all of your decisions are being made at a meeting of the board where you can hash this stuff out, where you can manage conflicts and do all that stuff. Okay, so we're a little bit over time. I'm going to cut it off there. If folks have additional questions, there's my email address. Thank you today for coming out to our webinar, and enjoy the rest of your day.